No mentioning before the 7 judges, sir. Send an email. You got my order. Thank you. In this matter? Oh, yeah, of course. But don't give it to us. Give it to the nodal council. He'll then put it together. No difficulty.
May please.
Do is, Mr. Paul, we'll just sort of, so that we give them enough time for the rejoinder. We'll give you about 40 minutes. 40 minutes to complete. 10 minutes for Guru and 10 minutes for Mr. Yatinder Singh. So that by 11:45 we will hand it over to them.
I'll just take 15 minutes more than the deadline given.
Now,
about an hour, I'll try and.
Mr. Paul, we know how precise you are. You can do it in 40 minutes.
Oh, no, that's a.
5 minutes.
Take the challenge. One hour for everybody together. 11:45 we are.
Can we?
Because the T20 challenge is always very stiff.
Just about 10-15 minutes more, Malot. A few.
Now 11:45. I think we have heard the matter very substantially. Now we have to hear the other side because
Mr. Nataraj and Mr. Vikramjit Banerjee also would assist for some time.
All in 1 hour. Yes.
We'll end up. We'll end up.
Generosity in these matters,
At some point of time, you know what happens is the judges also face a level of intellectual fatigue. Then you want to hear something in. You read the submissions in advance.
I hope that fatigue wasn't the result of my 20 minutes.
No, not in the least. Not in the least.
Yesterday, my lords, I was on para 8 and 9 of Basha.
Yes.
To say that the appellants cannot alter or expand the scope of reference. And taking off from where Mr. Devedi left on the principle of stare decisis. Now, whether...
That's very technical, you know. We have in a combination of 7, we are not strictly ever bound by...
I said so. I said so that I'm not saying for a minute...
Point. I think we more want an answer on the heart of the matter.
That way. But my lord, nonetheless, I'm entitled to say that if for 57 years, Basha in no judgment discussed has ever been doubted on whether established or administered factually, should your lordships at all get into it?
That point you have made.
That is all that I'm saying, my lords.
That point is well taken. We have made the point.
Yes,
Here the other.
I'm not so much on the stare decisis, but on the issue that if that's not part of the reference order, can you completely alter and rewrite the reference question? Because the question they have rewritten.
So, Mr. Paul, I'll just tell you what my notes say. 1, scope of reference dash Basha is not under review or appeal.
Yes.
In 56 years, it has not been in question. Only question in reference was whether and is conjunctive or disjunctive.
Yes, yes.
So we formulated your point.
Yes. And my lords, also keep in mind that when para 8 and 9 was being read out to your lordships yesterday of the reference order, one consciously the word question was used there in 8 and in 9. What is it that was referred to? Yashpal. For the purposes of that 2F, were established.
Now let's get on.
And my lords, one thing I missed out. In para 9, the last line and the last word was the para of Basha extracted above. So they were categorically on the question of what was extracted above, which was conjunctive or disjunctive. I'll go on to my next point.
Yes.
Next point, my lords. I must say this was a mistake on my part. I've also got it uploaded now, my lords, but I dictated to save time a short note on the 5-6 judgments relied on them by what they say, their contention and our answer. Otherwise, I could give a hard copy to your lordships because
it's already uploaded.
It is?
Yes.
Yes. Because these are the judgments they have relied on to say, because our whole submission is that there is nothing in law later on which contradicts or to which Basha is contradictory. Now, please have the first judgment, my lords, which is INRI Kerala Education Bill. My lords have that?
Yes, we can go to the second sentence.
Yes.
What I've done, my lords, is on the left-hand side are the findings and their contention based on the judgment, and on the right-hand side is our response to it. If your
Yeah.
Lordship, my Lord the Chief Justice has that. Judgment cited and contention. In re Kerala Education Bill findings. A bench of 7 judges of this Honorable Court in re Kerala Education Bill, while examining a reference on certain aspects relating to Kerala Education Bill, opined that the provisions such as minimum salaries and qualifications for appointment of teachers sought to be imposed on minority-run schools as a condition to receive aid were regulatory in nature, and that it would not offend the right of minorities to administer under Article 30 subclause 1. The Honorable Court held that the benefit protection of Article 30 subclause 1 would be available not only to educational institutions established after the commencement of the Constitution, but also to educational institutions established prior to the commencement of the Constitution. The Honorable Court also held that
Actually, Mr. Kaul, instead of reading what Kerala holds, you can read out your second column, your response. So let's
Very-
see what your response is, because Kerala.
would your Lordships want me to
That's
also?
better, no, brother?
Yes.
इसका response क्या है वो देख लेते हैं, more than anything else.
As your Lordships say.
I think
And
that's better, we'll
on
understand.
the left-hand side, I've also given their contention based on Kerala, and now the right-hand side. Firstly, the propositions laid down by the Honorable Court in Kerala Education are not being challenged by us. The judgment in Aziz Basha also does not deny that minority institutions could have been set up prior to the coming into force of the Constitution and would still receive protection under Article 30 subclause 1. The Honorable Court in Aziz Basha firstly analyzes the antecedent history of AMU and the subsequent enactment of the AMU Act 1920 to conclude that the very establishment of AMU was not by a minority institution in the first place. Further, the administration of the university, as mandated in the 1920 Act, lies with the central government, with final decision-making retained by the Lord Rector. Such control was not merely regulatory to prevent maladministration, but substantive in nature. The above finding is also made by the Honorable Court in Aziz Basha after an analysis of various provisions of the 1920 Act. In the facts of the case, in fact, a perusal of the provisions of AMU Act demonstrate that the 5 key administrative functions, admissions, levy of fees, governing council, appointment of staff, and disciplinary powers as identified by this Honorable Court in TMFI to determine the locus of administrative control are executed primarily by the Executive Academic Council in conjunction with the visitor, earlier Lord Rector.
Can you just hold for a minute over there? Just make a note of these admissions. Levy of fee.
Statutes. Speaking of statutes also, if your Lordships can add
Under the Act.
under the statutes and ordinances.
And ordinance.
Yes.
Therefore, the administration of university by the state cannot be simply viewed as reasonable regulations imposed in exchange for state aid. The administration of university by non-minority is substantive in nature because AMU is a central university and not a minority university receiving state aid. Then second is the judgment in Maroj Siddharaj Bhai, Sahbai versus State of Bombay, where the dual test was laid down. And here again on the right side, firstly,
Yes.
the present case regarding status of AMU is not a case involving mere regulations being imposed by the center for state aid being given to AMU. AMU stands on a different footing because the same was established by the then imperial legislature through an act of the then British government. Therefore, the administrative and regulatory provisions therein reflect the fact that the establishment of the university was by the central government and not by a Muslim minority. Finally, as submitted supra, the provisions of 1920 Act are not merely regulatory, but confer substantive control over the administration and management of AMU upon the non-minority bodies, including the visitor, the Executive Council, and the Academic Council. Then is State of Kerala versus Very Reverend Mother Provincial. Firstly, the Honorable Court in Mother Provincial does not state that they are rejecting the view taken by Aziz Basha. Secondly, the interpretation of the two rights to establish and to administer is consistent with how Aziz Basha interprets Article 30, subclause 1. In State of Kerala versus Very Reverential Mother Provincial, this Honorable Court merely held that non-minorities can also contribute to the establishment of a minority institution. However, Aziz Basha also does not deny such interpretation, but merely holds that in the facts of AMU, the establishment of the university was by a statute and not by any minority community. Thus, the Honorable Court in Aziz Basha, after highlighting the role that is required of the minority in the process of establishment of an institution, concludes that in the facts of the AMU case, the criteria is not met. With respect to the establishment in State of Kerala versus Very Mother Provincial, this Honorable Court held the administrative powers of management of the affairs of a minority institution cannot be taken away. Even with respect to the administration, the Honorable Court in Aziz Basha undertakes a detailed analysis of the 1920 Act and after assessing the same concludes that the management of the affairs of the institution did not lie with the minority institution and was with the central government. Therefore, in Aziz Basha, this Honorable Court not only laid down the broad principles of Article 30, subclause 1, but also undertook a factual analysis of the 1920 Act to hold that the administration of AMU was never envisaged to be in the hands of minority community. No subsequent decision has held that the factual analysis undertaken by Aziz Basha requires reconsideration. Then St. Stephen's College. In the Honorable Court in St. Stephen's case discusses the ratio of Aziz Basha and then proceeds to rely upon the decision in a different case, S.K. Patro versus State of Bihar, because S.K. Patro was found to be in close parallel with the case on hand. Therefore, the Honorable Court in St. Stephen's was conscious of the Aziz Basha judgment, but did not make any finding that the finding or decision in Aziz Basha required any reconsideration. Further, with respect to the importance of historical antecedents, the importance and relevance of Mao College was already considered by this court in Aziz Basha, and only thereafter the Honorable Court made a finding that the establishment of AMU by the then legislature was the founding of a new university and the absolute dissolution of the Mao College. In fact, the Honorable Court notes the nucleus of the Aligarh Muslim University was Mao College. Thus, the Honorable Court concludes that the conversion of Mao College from a college institution into a university was, however, not by the Muslim minority. It took place by virtue of the 1920 Act, which was passed by the central legislature. At the same time, it is also important to note that in fact the Honorable Court in St. Stephen's approves the conjunctive test laid down by Aziz Basha and holds that a minority institution must be established and also be administered by a minority community. Now please have TMA Pi, the next page. It is submitted that the issue in Aziz Basha was not regarding whether admission of non-minority students would not affect the minority character of an education institution. This Honorable Court in Aziz Basha does not hold that minorities do not have a right to establish and subsequently administer religious institutions. It merely holds that in the specific case of AMU, neither establishment nor administration lay with the minority community. In fact, in TMA Pi, this Honorable Court laid down the indicia of administrative control, which was then relied upon by the Honorable High Court of Judicature at Allahabad to analyze and hold that none of the indicia of the administrative control in the case of AMU lay with the minority community. Accordingly, the Honorable Allahabad High Court thereafter found that the 1920 Act never envisaged administration of AMU by a minority. Now, my lords, coming to some of the specific points raised
Paul?
The next point is, my lords, the 1981 amendment does not remove the basis of Basha. My lords, the establishment of
In analyzing this aspect, we'd like you to dwell separately on the establishment aspect of Basha and the administration aspect of Basha separately.
right.
So, to what extent did the 1981, because Basha held both, that it was not established by a minority, and second, it held it was not administered by a minority.
Yes.
Now, when the 81 amendment comes, does it take away the basis of Basha both in relation to establishment and
Yes,
So we'll have to deal with it separately.
Yes, yes, yes.
So this is not a question; it's just a
Yes,
suggestion.
yes, I'm very grateful. My lords, the establishment of AMU by the then colonial British government is a finding based on historical fact. That the Mao College was dissolved, that a new university by the name of AMU was established, and this was a university established by the then central government and not by Muslims. These are historical facts.
So just repeat it: dissolution.
My lords, the
Of MOU.
establishment of the AMU by
The
the then
historical fact, and you identified the
when Mao
features.
College was dissolved.
Yes.
That's what it is.
Then
The Mao College was dissolved, that a new university by the name of AMU was established, and this was a university established by the government and not by Muslims. After detailed negotiation. And giving up of many rights as an institution that they may have possessed before coming forward to the central government negotiating and an act coming into place. Now, by introduction of the word,
by deletion of the word established,
by deletion
There's
of the
two
word
things.
established and amending the definition of
Of
university, you cannot remove the basis of Basha which recognized a historical fact. And that was not laid down as law by Basha but held to be a fact. Basha recognizes a historical fact. The change in legislative history is not possible in the manner the 1981 Act is seeking to do. That cannot happen. You can't change legislative history. And a historical fact cannot be revised or altered either by a legal fiction or by a parliamentary fiat. Either of the two cases. If it's a historical fact, it remains a historical fact. A legal provision can be changed. But how do you remove a historical fact? And as your lordships in Indra Sani held, that a fact cannot cease to exist only because they are denied. If a fact is there, it's there. You can't by a subsequent legislation say, I deny this fact. You can't alter legislative history. The fact is an act came into being. The fact is that Mao was dissolved. The fact is that a new university came into existence after negotiations. This is about historical facts, and that is why the late Somnath Chatterjee, my lords, one of our most erudite parliamentarians, and that is in the Solicitor General's written submissions on page 113, categorically said that changing the definition of university was, as it was done, which was established by a statute, and once an institution was established in a particular manner, such manner of establishment could not be changed through retrospective legislation, as legislation cannot change history. That is what the late Somnath Chatterjee said. You are today seeking to argue that by the change in definition of university and by removal of the word establishment, we will change a historical fact.
Reference of Mr. Somnath.
The Solicitor General's written submissions are on page 113.
You can, Mr. Call, you can continue. Ask one of your juniors to just give us, in a minute, the specific, not from the submissions, but the actual document, what page it is. Anybody can give it in 2 minutes.
Yes,
Just
yes,
don't get deflected. We'll hear it so that we can complete your submissions.
Yes, my lords, I just. As far as administration is concerned, my lords, my respectful submission is, and those are my instructions subject to correction, that the 81 Act does not deal with administration at all. It only deals with this definition of university, and for them, that's what it deals with, an establishment being removed. The minister rejects it and says we will not go into administration. Now, my lords, the second point for your lordship's kind.
I think you are on firmer ground on the second aspect as compared to the first aspect. Frankly, I have some doubts about whether you are right on the first aspect. Because when Parliament deleted the word established by the 1981 amendment, in that sense, if you are going to delete the word establishment, then the entire incorporation of the university would have to come to an end. But possibly it was open to Parliament to take a particular view that what the 1920 Act did was to give it a form of a statutory university. But it does not dilute from the fact that this was still established by Muslims.
Creation of a university by a statute.
Fair enough. But on the latter part, that the 1981 does not take away the basis of Bhasha, you may be on firmer ground, because the 1981 Act makes no change to the administrative provisions of the 1922 Act at all. It leaves them intact.
I'll only endeavor to persuade your
On the
lordship
first point also.
that I'm equally on an equally firm ground. That's my endeavor, just to persuade the honorable Edge. My lord, ultimately,
Mr.
what
Kaul,
was
your best argument on that is, once the university is established pursuant to a particular enactment,
You can't just say it's not established.
but then,
Because then you would be going back to what? There would be a void.
my lord, I can't better. That's exactly what I'm saying. That is the sum and substance of my first argument. That's what I respectfully submitted.
because
I'm on
something
equally
once
firm
it's
ground.
established, you can't change it.
You can't then say
But
it's
then-
not there.
But then virtually what you are arguing, and that too on the part of the respondents, where government is also doing, government is also on that side, is taking virtually now saying that this part does not vest with the parliament.
Maharaj, I'm going to the
Therefore,
extent of saying that even by a
We are
legislative,
accepting then this part.
I'm saying so. This is my submission that by a legislative fiat or legal fiction, you can't take away a historical legislative fact. You can't alter legislative history. That's my submission. Whether the government can make it or not is another issue. I can surely
Again,
make
there
it.
will be a little problem conceptually, because it is always open to the legislature. The legislature is not bound to take notice of facts as they emerge, as you and I would think that they emerge, but the legislature is always entitled to take a
But my
artificial
lord,
view of
as
facts.
your lordship just said,
Power of
as-
the legislature.
as
That's
your
what they do all the time in
Not a-
income tax law.
as your lordship just said, a
I
minute
was
back.
paraphrasing your argument, not accepting or rejecting that argument, because it's also well settled that the legislature can make laws with retrospective effect.
No difficulty.
Suppose they were of the view that they by mistaken notion used the word established there, they could have always removed it, because the court acted upon that basis.
So I'll just go back to what your lordship just summarized so well. That can it be said that something was established by a legislation?
Mr. Paul,
Say we are not recognizing.
You are also appearing on the side of the government in the eagerness to, uphold the striking down of the 81 amendment. Let us now do something which substantially cripples the powers of Parliament. And we should be very averse
Yes,
to
but
taking
my lord-
that kind of an
But my
interpretation.
lord, my submission is
for the
slightly,
future.
my submission is slightly different. I'm on the point what your lordship
So,
also just
in
summarized.
the effort to sustain the decision of the Allahabad High Court and, get over the 81 amendment, shouldn't be doing something which, we means you, which really in that sense will substantially
also, my lord-
dilute the powers of Parliament for the future. We have to be very careful, because what we are
Right,
laying
fair
down
enough,
is
fair
law for the future.
Fair enough, but what
on
your
the
lordship,
powers of a constitutional body.
but what your lordship also said, that at the same time, ultimately, my lord, there are actions of parliament as well which are struck down. There are actions of parliament which are also held to be ultra vires. The
And I'll tell you
Constitution.
why this may not be entirely correct. Parliament is entitled to say that we take a particular view of the expression established
Right.
as opposed a factual view as opposed to a legal view. Now we got your point that even on the facts, there's a historical fact with Bhakta.
All that I am saying, my lords, that is my limited submission on that. That is
Parliament
what
can
Justice
make that
Khanna
distinction
summarized is my
between-
limited submission on the point.
Parliament can make that distinction between incorporation and setting up.
Yes.
And to say that, well, what was meant by the word established, what we mean by the word established is actually the factual setting up, not the legal form which is given to it by the incorporation of a university possible. So let's not sort of, go into a wider context and sort of dilute the powers of Parliament by laying such a broad proposition that is not open to Parliament while legislating to take a view of historical facts to the contrary, even if it is embodied in a judgment of the
This
court.
meaning of,
Let's not.
all I'm saying is, my lords, this meaning of established also in a way.
That's why I
gets
said your second point, you're probably on a surer footing.
No,
That
I'm-
you have never changed the administrative basis of the
And let me
1920 Act in
complete this,
1980.
and let me just complete it.
But now you've made your
And
point.
on established also, read it in conjunction with entry 63 list 1,
National,
where it's brought in as a university of national
that
importance.
point has already been made.
That's why I said, my lords, don't read established alone. Read it in conjunction with what did Parliament intend? Or what did the Constituent Assembly, when the Constitution was being drafted, intend? When entry 63 list 1 came in, a university like Banaras Hindu University of national importance, without any communal tag at all.
Interesting, entry 63 uses the expression established in relation to universities which are established under Article 371E. I just wanted to check whether they use the word established in relation to AMU and BHU. Doesn't matter, but that factual.
No, my lords, just for the completeness of the narrative.
Which says
Yes.
the university is referred to as AMU and BHU at the commencement of this constitution.
Right. May I, my lords, proceed with the.
There is one aspect, of course, which still is a point which may weigh in your favor, which is that entry 63 of list 1 contains a constitutional understanding in regard to the status of AMU and BHU. So it freezes that constitutional understanding as at the date of the commencement of the Constitution. Now, if the Constitution adopts a particular understanding of these two universities, these two institutions, which says institutions known at the commencement of the Constitution as AMU and BHU, can a subsequent legislature alter that constitutional understanding, which is the foundation of NT 63?
So what fell from my lord the Chief Justice,
That too without.
except for a constitutional amendment.
Of the constitutional.
Without
Yes,
constitutional.
without a constitutional amendment, you cannot.
Because now one thing is very clear, that NT 63 tells us that as an institution of national importance, these two institutions are those which were known as such at the commencement of the Constitution. And then can you, by a legislative fiat, alter that constitutional understanding which forms the basis of NT 63?
In fact,
That's the specific
Entry
point that they
63,
raised, that
entry
that
63 is a constitutional declaration.
would amount to amending the constitution. As it-
That will be true even for 1951
No, there is no change in my lord.
and 65.
No, there is no
There is
change.
none, there is none.
the character of the
Bringing
university
in-
is not.
No, but those are amendments
It's
to
bringing
the,
conformity with part.
they are also amendments.
In
with-
fact,
Three.
in fact, frankly, they bring it in conformity.
With part.
Yes. Now, my lords, the second point, since time is yes. My lords, the next point for your lordship's kind consideration is that the administrative functions of the AMU are primarily carried out by 4 bodies. visitor, the executive council, the academic council, and the AMU court.
Visitor, academic council,
EC.
A visitor, executive council, academic council, and the AMU court. Now, if the 5 key administrative functions as per TMA-5, which disclose where does the locus of administrative control lie, are looked at, which are admissions, levy of fees,
Actually 6 now.
yes, governing councils, appointment of staff, disciplinary powers, and ordinances and
Now
statutes.
statutes and all.
Statutes
That
and
we have
ordinances
read.
are looked at. The locus of administrative control as executed primarily lies with the executive and the academic council in conjunction with the visitor. And the AMU court is not the supreme body. Now, what is the argument sought to be made? That 32 Muslims are always meant to be there approximately out of 180 members of the AMU court. Now, admittedly, they are not in a majority, as the legislation does not require them to be a majority. What you are seeking to say is that de facto, by fortuitous circumstances, because they happen to be in a majority, treat this as a minority character. It can't be. The legislature, if it wanted, could have done so. But the legislature consciously does not provide for it and puts it only at 32 out of 180 or approximately that number. Now, in fact, because they turn out to be more, can't alter a legislative fact that they're not meant to be in a majority, are not expected to be a majority. The legislature doesn't mandate that to happen. And the highest that can be said, my lords, is that the AMU court is one amongst many administrative bodies with essential powers vested in the executive council, academic council, which are not minority-led.
Okay, next.
Yes. Manoj, next an argument was sought to be made that there is a difference between established by and established through. And it was said that it may have been established through a statute, but it was established by a minority. Now, Manoj, with great respect, these semantic distinctions are not borne out from the 1920 Act at all, which uses the term an act to establish and does not anywhere aver to the fact that the government is merely recognizing an existing institution to be a university. There is a huge difference, my lord, when a college like St. Stephen's College is looked at. A minority institution whose character as a minority institution is analyzed is affiliated to a secular university. That's very different. There the questions come in is, what are the nature of regulations can you put? Can you, as a condition for affiliation, say that they cannot have a separate interview? Their cutoff date can be the same or not? Can, while granting them aid, can you put regulations which are so onerous that it takes away the minority character of the institution? That's a very different category of cases. They did not come to the central government and say, create a statute, and negotiated, and a statute was passed to create St. Stephen's as a college or a university. We are dealing with a case where, for historical reasons, you came, negotiated, and ultimately, in the facts as they existed in 1920, by virtue of a statute, an act to establish, as it said, the university came into being. So you can't give those examples, and then you use semantics like by, through. It's irrelevant, because the statute doesn't provide for that.
Mr. Kaul,
Yes.
isn't St. Stephen's also governed by substantial extent by the statute and ordinances of the University of Delhi?
Manoj, maybe, but that is still an affiliated to the Delhi University.
Correct,
Now, if
correct.
an issue arises there because it's a minority college, they went into issues, Manoj will recollect in the judgment. Where is the chapel? The principal comes from the North India Church. Many such examples were given to establish it as a minority institution there. And still affiliation was being looked at. We are talking about the very creation. Here, the preamble in section 4 said Mao College stands dissolved. All institutions connected with it, bodies connected with it stand dissolved. Ceases to exist. Where is the parity between the two? How can you even rely on an example of St. Stephen's College to cite AMU? And AMU is then put in list NT 63 list 1.
When St. Stephen's College decided to become an affiliate of the Delhi University, did it not give up some of its rights?
None of it.
Manoj, that is why
That St. Stephen's could have also continued the way it is, given degrees which had no value or may not have legal as or permitting to get government jobs, etc.
that is why, my lords, why I was wanting to read those judgments where your lordships told me to read the right and the left. All those judgments were cases of regulatory provisions like quality of teachers, academic qualifications of teachers, the way admissions are made, etc. Those are regulatory in nature so that academic standards are maintained.
So you are then drawing distinction. Now here you are now drawing distinction between regulation
I,
and
in
will
my
that-
note, read out,
will-
yes,
will
with
that-
substantive
just-
manner
just one minute.
of control.
Just one. Will that equally apply as far as when we refer to AMU is also concerned? Did they agree to get regulated in a way when they got sought and got the government permission?
Manoj, that is
Or
our,
did they give up their minority?
that is
content?
our whole cases, and as is both recognized in the impugned order of the Allahabad High Court judgment and in Aziz Basha, that when you came and negotiated, you agreed to get the degrees recognized, all our bodies, all our Mao College cease to exist, they stand dissolved. And we will now be guided by the detailed provisions of the Act on Administration
Understood. That-
and Establishment.
That we have understood.
And governmental control is accepted. Colleges as Mao was affiliated to Allahabad, since Stephens was affiliated to Delhi University in this matter, Mao in its original avatar. Now, since Stephens continued in the same skin even after affiliation. Remember, Manoj, that is why I said. See, David's emphasis, the chapel over here and there. But since Stephens, as I respectfully submitted, continued in its same skin even after affiliation to a university like the Delhi University. And what were the grounds taken there? The grounds taken there were, where was the management? Management was at the minority. Illustratively, it was shown that the college looked after religious and moral instructions to students. The principal of the college was to be a member of the Church of North India or of a church that is in communion with the Church of India. All those factors came in. So it was held to be a minority institution.
And why 1920 Act contain a schedule which refers to those founding members?
Yes.
Why does the imperial legislature recognize what it calls the founding members?
Again, I would respectfully say that if a historical fact is incorporated to say these are the founding members, does that take away and does that have to be read so exclusively and selectively without reading the entire act together? If the entire act is read together merely because founding members are mentioned therein, what about the way it's established? What about the way it's administered? Will everything be overlooked? So we can't pick and choose bits and pieces to come to a conclusion that it is a minority institution. We can't pick up and say, look, here they said founders. There was another reference to the historical antecedent, but what about the core, the heart of the matter? The flesh and blood of the matter is...
Mr. Kaul, what else now remains?
Just one or two submissions.
All right, let's just formulate them so that we'll move on.
My respectful submission for your Lordship's kind consideration at the end is this, that the entire argument has been that historical facts have been ignored and antecedents have been ignored. They have not been ignored. And then the argument is sought to be made that if that logic is accepted, then no minority can ever be set up as a university. Now, firstly, there is the NCMEI Act in itself, one which has its own provisions. B, there is no doubt now, historically as recognized in repeated Supreme Court judgment, that a university can only be set up under the UGC Act. But the deeming provision provides for any institution to come and seek a deeming status. So this whole argument that minorities and their rights are in danger is a completely misplaced argument of prejudice and nothing else. And lastly, my lords, the appellant said, as a continuation of this argument, lastly said that after all, what are we asking? We are just asking for a bit of reservation and you're snatching it away. That was an emotive appeal made. Now, my lords, my respectful submission is that when did you have reservation? The judgment in Basha has been in place for 57 years. You never had reservation till the 2004-5 with that then change of government, when the provision was made for reservation and which was ultimately struck down in the Allahabad High Court judgment. So which reservation is being taken away? Which right of minorities is being taken away? What is being done that the fabric of a secular country is being in any way pierced or destroyed? What is being done? You're almost making it look as if something is now being done, which completely destroys the minority character and snatches away all the rights of a minority institution. It does not do so. You're as protected as you are entitled to be under the Constitution of India as equal citizens, and whatever are the rights of the minorities under the Constitution. Maharaj, I'm very, very grateful. Your Lordships have been extremely
Thank you, Mr. Kaul. Thank you.
I'm very grateful.
Yes, Guru.
That's that. My apologies if,
Your Lordships leave my notes.
Yes, certainly, Mr. Kaul.
if I sprint through some of my submissions, my lord, my apologies given the time frame, my lords. Broadly, 4 things that I wanted to highlight to my lords.
What is the first?
First, the importance of entry 63 and inclusion of AMU in the constitution itself in entry 63. That's one, my lords. That, in my respectful submission, is really a crystallization and cementing of the position of AMU as a non-minority national institution. That's the first point I want to highlight, my lords. Second point, my lord, the claim of AMU to minority status on the footing that a pre-constitution institution also is entitled to Article 30 protection.
What is the second point? Claim
Second
of-
point is the claim of AMU to protection of 30 on the footing that notwithstanding that it's a pre-constitution institution, it can still avail of Article 30 protection, has to be seen from two time zones or time frames in my respectful submission. Pre-constitution and at the commencement and thereafter. That's the second point, my lord. What were you prior to the constitution? What was your position? And what did you become? Or what is it that continued at the time when the constitution was adopted? That's the second point, my lords. Third, connected to that, my lords, is with regard to the fallacies which are the infirmities in Aziz Pasha has argued. There, my respectful submission is, my lords, the formulation of the contours of 30 at the instance of the appellant, my lords, is unsustainable. Their formulation of what constitutes 30 right is incorrect. I'll specifically refer to Dr. Dhawan's submission on this point, my lord. Fourth point, my lords, is 2 and 3 are really, to that extent, my lords, they overlap. Fourth point is, my lords, on the effect of the 1981 amendment. I think if there is any need to look at any case law, my lords, straight away there'll be two which directly in my submission answer the point. One is Indira Sani 2. The second, my lords, is Mulle Periyar, Constitution Bench decision of this Honorable Court. Both judgments, my lords, talk of how legislatively declared facts cannot override factual decisions of a court. Validating power, notwithstanding its plenary nature, to the extent of even being retrospective, cannot undo factual conclusions which are final and binding on parties. Direct are, my lords, Indira Sani 2 and Mulle Periyar. I've given those in my submissions, my lords. I'll show that. Now, coming to the first point, my lords will see that entry 63 is part of the string of entries in list 1, being 62, 63, and 64. 62 deals with historically important institutions, Imperial War Museum, another museum, National Museum, etc., etc. That is 62. 63, with which we are immediately concerned, my lords, deals with two named institutions, namely BHU and AMU. Thereafter, Delhi University, established under 371E, and any other institution declared by law to be an institution of national importance. 60. Take it out.
Three entries use the expression institutions declared by Parliament by law to be
Yeah.
of national
National
importance.
importance, yes.
63, 64, and 62, 63, and 64.
That's right.
In 62,
Yes,
it refers to three specific institutions: National Library, Indian Museum, Imperial War Museum, Victoria Memorial, and Indian War Memorial.
that's right, my lord.
And these five.
Yes.
And then it says any other like institution
Yes,
financed by government,
yes,
wholly or in part, and
Yes.
declared by Parliament to be an institution of national importance.
yes.
So 62, that residuary power of the residuary clause refers to any other institution of a like
Nature, correct.
So it has to be like, an archive.
That's right.
It's an archive or a museum.
Something
So
of
under
historical
62,
importance.
Right. On 62, the power relates to declaration of an archive
I bought on.
or a library or a museum.
That's correct.
When you come to 63,
Yes,
it refers to two institutions,
by name,
BHU and AMU.
correct.
And it doesn't say of a like nature. It says any other institution
I-
declared by Parliament.
I am obliged to my lord for that for one reason, my lords.
Now,
During the
64, if you
Yes.
go to 64, it refers to institutions of scientific or technical education financed and declared by law to be institutions. So 64 governs a specific class,
class of institution.
namely institutions of technical or financial education. 63 gives the general power to Parliament apart from these two.
That's right.
And 63 and 62 refers to, those archives, libraries or museums.
Institutions of historical importance.
But all three entries use the word declared by Parliament to be
Of national importance. I bow down to my lords for the observation on 63. I'll tell my lords why.
But Guru, there's one aspect,
Yes.
there is nothing fundamentally inconsistent
Yes.
with a minority institution being an institution of national importance.
No, there I have
also
a
we
point
have
to
to, that also we have to understand.
No,
More issues, sir. This is
Yeah.
a good.
no, I have a submission to make on that.
You can have a minority institution which also Parliament may by law.
No, I
declare to be
understand.
a national
I bow down to, the point is well taken.
There's no
I'm on something
difference
slightly different. No, what fell from my lords on 63 is important. Unlike 62, which talks of a like institution, 63 doesn't have. During the Constituent Assembly debates, an amendment was suggested saying for 63 also, it has to say similar institution. That was rejected, and in the process of discussion, they talk about the national character, which is non-communal of BHU and the AMU. That is what is important, my lords, for my lords' purposes. That is what I wanted to show. My lords, the Chief Justice's point is well taken, that like institution is not found in 63. A similar amendment was suggested when draft 63 equivalent to 40 and 40A of the draft constitution was moved. One member, Naziruddin, he said, should it not be similar institution like BHU and AMU? Dr. Ambedkar says, no, we want width of power to take over any kind of institution because these are institutions which are of national importance, which go beyond sectarian and communal character.
Is that, just show us just that relevant part of the Constituent Assembly debate
Yes,
on when they discuss national, on this entry.
Yes.
This entry.
In my submission also, in my submission,
My
sorry.
written submissions, page 12. We have
Just show us
quoted,
that,
verbatim.
can we go, do you have the CAD directly instead of going through the submission? Just like-
2B, volume 2B, page 12.
No, that is in the submission.
In the submission, do you have the Constituent Assembly debate?
Debates itself we have.
Just show us that, let's go directly to the
4B,
debate.
my lords, 4B, 115.
4B.
Yes. In my submissions, we have given extracts.
Because we'd like to read around it also.
I
around
understand,
that
Lord.
quote. Sometimes it's good to see the original text, so we understand
I understand.
page what, 4B, volume 4.
114, my lord, will start with, my lords. That relevant portion of Mr. Kaman's. And then Dr. Ambedkar also I'll show. My lords got that, my lords. 114. Can I read that, my lords? 114, Act 115. Taking my first amendment first, I feel that the acceptance of the amendment moved by Dr. Ambedkar referring to an institution which may be declared by Parliament by law to be one of national importance. I am not referring to Delhi University at all, but the second part of the amendment is fraught with dangerous consequences. I hope the House will pause to consider whether such a sweeping provision for bringing within the purview of the central government any institution, which of course Parliament may declare by law to be of national importance, is at all necessary. House will see that in the previous entry 39, which we have passed, We have given power to the Union to legislate about any institution financed by the Government of India, wholly or in part, and declared by Parliament by law to be an institution of national importance. This entry goes further and gives power to the Union to legislate in regard to institutions, whether financed wholly or in part or not at all by the Government of India. I have in mind certain institutions in this country which are doing very good work, wholly privately run, but run on efficient lines without any governmental interference. Amendment just now moved by Dr. Ambedkar shows that this grabbing instinct of the committee is growing by leaps and bounds, and if this passes muster, if this is accepted, I'm sure the day is not far distant when the acquisitive instinct of the Union will run riot, and the Union will try to step into so and so. Then the next para. As regards the two universities mentioned in this entry, it should declare by law those institutions to be of national importance. But in modern times, he goes into all of that. Now, this is one part where they specifically, please come back to that. As regards the two universities mentioned in this entry, the Banaras Hindu University and the Aligarh Muslim University, of course, either it may be true that they are of national importance, or because they have the communal tag attached to them, meaning to suggest, my lords, the name. The government, to show their impartial, non-communal nature, might legislate in regard to those universities. So even this person who opposed, my lords, the sweeping language of 63, where it says by Parliament can take over, says for BHU and AMU, you are justified because you want to show that they are of national importance. They should not be carrying any communal color because of the communal tag attached to their names. And in fact, Nazaruddin, the other member, my lords, he also talks about the amendment which he wants to do. Please come to 112.
How does Dr. Ambedkar respond to all this?
Now, Dr. Ambedkar, just 1 minute, my lords. Just give me a minute on that. Can I show Nazaruddin for a minute, my lords?
Sure.
That is at 112. I have slightly altered my amendment to suit the change introduced by Dr. Ambedkar in his own amendment. I submit that Dr. Ambedkar's amendment would unduly enlarge the jurisdiction of the center, and many things which would be otherwise cognizable by the provinces would now, by virtue of the words which I seek to delete, be included within the jurisdiction of the center. The Banaras Hindu University and the Aligarh Muslim University have been regarded from the very inception as institutions of a national character and importance, and therefore they have been rightly regarded so far as national institutions, and they have been rightly placed under the jurisdiction of the Union. Then, my lords, he goes into the question of any other institution, where he says you must have it for similar institutions. That is the burden of the song in Nazaruddin Ahmad's, my lords, submission and statement in the debate. Now, please come to page 118. Now, please see, I find my honorable friends, Mr. Nazaruddin, Dr. Deshmukh, running at cross purposes. One wants to enlarge the scope of the article by adding the word academy. Other wants to limit the scope of the article by adding the word Delhi University and any other institution declared by Parliament by law to be an institution of national importance. So far as Dr. Deshmukh's amendment is concerned, it seems to me quite unnecessary to introduce the word academy because the word institution is large enough to include both university and academy. Therefore, that is quite unnecessary. With regard to the amendment of my honorable friend, Mr. Nazaruddin Ahmad, Delhi University as was pointed out by him already under the central legislature by virtue of the fact that the university is in a commissioner's province, which is subject to legislation of the center. Therefore, in introducing the words Delhi University, we are really not departing from the existing state of affairs. With regard to the subsequent part of the entry relating to any other institution declared by law by Parliament, it seems to me that it is desirable to retain those words because there might be institutions which are of such importance from a cultural or from a national point of view, and whose financial position may not be as sound as the position of any other institution and may require the help and assistance of the center. In view of that, I think the last part of the entry is necessary.